a nice day. Did you answer all questions related to our previous topics? Yes. Somebody messaged to me that they did all. Please do all. Thank you, my subscribers and viewers. Thank you for all supportings. Please continue your support. Okay. If any doubt, you can ask me or message to me. Okay. In constitutional law, today we can discuss the topic justiciability of fundamental rights. What is the meaning and nature of justiciability? Constitution of India guarantees fundamental rights. Constitution of India guarantees fundamental rights. Article 13, that is Article 1(3), makes the fundamental rights enforceable in the courts. Article 1(3) makes the fundamental rights enforceable in the courts. It declares that all laws, whether pre-constitutional or post-constitutional, void if they are inconsistent with or violate the fundamental rights. Any law, if they are inconsistent with or violate the fundamental rights, that will be considered as void. The citizens can seek the assistance of the courts for the enforcement of their fundamental rights under Article 32 before the Supreme Court and under Article 226 before the High Courts. Under Article 32 before the Supreme Court and under Article 226 before the High Courts. Thus, the Supreme Court or the High Courts have the power to issue directions or orders or writs for the enforcement of any of the fundamental rights. According to the case L. Chandrakumar versus Union of India, All India Record 1997, Supreme Court 1125, it has been held that all the laws and legislative actions are subject to judicial review and the higher judiciary exercises this power. Higher judiciary exercises this power. Judicial review is the basic structure of the Constitution of India. Judicial review is the basic structure of the Constitution of India. Therefore, the courts can declare a law unconstitutional if it is inconsistent with the fundamental rights. If any law inconsistent with the fundamental rights, that will be declared as unconstitutional. This case we can see that in Golaknath versus State of Punjab, All India Record 1973, Supreme Court 1461, and Dasharatha Ramravu versus State of Andhra Pradesh, All India Record 1961, Supreme Court 564. It has been held that a custom or a usage having the force of law has been held to be law under Article 13, 1(3), Article 13. It has been held that a custom or a usage having the force of law has been held to be law under Article 13. Next we can see what is the judicial review. Judicial review is the power of High Courts and Supreme Court to pronounce upon constitutionality of all legislations past as well as future under Article 226 and 32. Judicial review is exercised to check any uncontrolled executive functioning. Judicial review means to check any uncontrolled executive functioning. It is judicial control over administrative action. Judicial control is judicial review is judicial control over administrative action. Do you understand? Yeah. Next, Keshavananda Bharati versus State of Kerala. One of the case relating to judicial review is that Keshavananda Bharati versus State of Kerala. All India Record 1973, Supreme Court 1461, 1461. Popularly known as Fundamental Rights Case. Which case is popularly known as Fundamental Rights Case? Keshavananda Bharati versus State of Kerala. In that case, Justice Khanna held that judicial review has become an integral part of our constitutional system. According to that case, Justice Khanna held that judicial review has become an integral part of our constitutional system. This case is that in Epuru Sudhakar versus Government of Andhra Pradesh, on the record 2006, Supreme Court 3385. It has been held that the President and governors should use their pardoning power as an act of grace and humanity in proper cases. They have no obligation to convey reasons, but it does not mean that there should not be reasons. Pardoning power is open to judicial review on limited grounds. Pardoning power is open to judicial review on limited grounds. Next, what do you mean by doctrine of severability? Doctrine of severability is also known as doctrine of separability. It means where only a part of the law is inconsistent with or contravenes the fundamental rights, it is only that part which shall be void under Article 13 and not the whole of the law. If any part is void, that will be filtered from that legislation. The rest of the law will be valid, will become valid. Severability means separability. It means where only a part of the law is inconsistent with or contravenes the fundamental rights. It separates the valid portion of law from the invalid portion. If the provisions of the legislations are not possible for separation, the entire legislation is treated as void. The entire legislation will be void if there is no separation. If a separation is not possible, the entire law the entire legislation will become void. According to case A.K. Gopalan versus State of Madras. Which case? A.K. Gopalan versus State of Madras. On the record 1950, Supreme Court 27. The Supreme Court struck down Section 14 of the Preventive Detention Act 1950 as violative of the fundamental right under Article 22. In that case, Supreme Court struck down Section 14 which find as violation of the fundamental right under Article 22. Next, what is the rules of severability? There are four rules relating to severability. First rule is that intention of the legislature determines severability. Intention of the legislature determines severability. Next rule is that history, object, title, preamble also decides severability. History, object, title, preamble also decides severability. Next rule is that invalid portion cannot be enforced without alterations. If any portion is invalid, that cannot be enforced. That must be altered. Next, four cases that inseparable. Invalid portion makes entire law void. If any portion cannot be separate from the entire law, that entire law will become void. Okay. Next, doctrine of eclipse. What do you mean by doctrine of eclipse? Eclipse. Eclipse means hide or cover. Hide or cover. Sometimes the law becomes ineffective or inoperative for the time being. This is called eclipse. Sometimes the law becomes ineffective or inoperative for the time being. This is called the eclipse. One of the cases relating to that doctrine of eclipse is that State of Gujarat versus Sri Ambika Mills. All in the record 1974, Supreme Court 1300. State of Gujarat versus Sri Ambika Mills. It has been held that the doctrine of eclipse is not applicable to post-constitutional laws and not non-citizens. It has been held that the doctrine of eclipse is not applicable to post-constitutional laws and not non-citizens. In Bikaji Narayan versus State of Madhya Pradesh, on the record 1955 Supreme Court 781, it has been held that by a suitable amendment, the law would get revived and operative after removal of the shadow cost of the fundamental rights enacted subsequent to the commencement of the Constitution of India. We see the two cases, that is Gujarat versus Sri Ambika Mills and in Bikaji Narayan versus State of Madhya Pradesh. In both these cases, what we see? Yeah. The doctrine of eclipse is not applicable to post-constitutional laws and non-citizens. Next, the law would get revived and operative after removal of the shadow cost of the fundamental rights enacted subsequent to the commencement of the Constitution of India. Next, what do you mean by doctrine of waiver? Waiver, what do you mean by waiver? Waiver means losing or giving up. Waiver means losing or giving up. Fundamental rights are guaranteed to every citizen. Every citizen must follow fundamental rights. The citizens has no right to waive the fundamental rights. No right to waive the fundamental rights. According to the case, Bashasharnath versus Commissioner of Income Tax, All India Record 1959, Supreme Court 149. Bashasharnath versus Commissioner of Income Tax. In this case, Bashasharnath concealed a large amount of his income and caught by the Department of Income Tax. He concealed a large amount of his income and caught by the Department of Income Tax. In the year 1954, he agreed to pay 3 lakhs in monthly installment by way of arrears of tax. How much amount? 3 lakhs as arrears of tax and penalty under section 5 subsection 1 of the Taxation Income Investigation Commission Act. Taxation Income Investigation Commission Act. According to that act, it has been held that section 5(1) of the act as ultra vires of article 14, section 5 subsection 1, section 5 bracket 1 of the act as ultra vires of article 14. Bashasharnath claimed the recovery of amount paid by him. Bashasharnath claimed the recovery of amount paid by him. The respondent contended that the petitioner had waived his fundamental rights and agreed for the settlement. It has been held that the citizens could not waive his fundamental rights. The citizens could not waive his fundamental rights. Therefore, the petitioner was entitled to recover the amount. Therefore, the petitioner was entitled to recover the amount. Next, what are the points to remember from the above explanations? Points to remember. First point is that Constitution of India guarantees fundamental rights. Constitution of India guarantees fundamental rights. Next point is that Article 13, that is Article 1(3), makes fundamental rights enforceable by the courts. Article 13 makes fundamental rights enforceable by the courts. Next, judicial review is power of courts to state constitutionality of legislation. Judicial review is power of courts to state constitutionality of legislation. Next point is that judicial review is to check uncontrolled executive functioning. Judicial review is to check uncontrolled executive functioning. Next point is that doctrine of severability is separation of law with fundamental rights. That is like a filtration. Doctrine of severability is separation of law with fundamental rights. Next point is that it separates the valid portion of law from the invalid portion. It separates the valid portion of law from the invalid portion. Next point is that during eclipse law become inoperative. During eclipse means shadow. During eclipse law become inoperative. Next, the provisions of a statute may not be enforced during eclipse. The provisions of a statute may not be enforced during eclipse. Next point is that doctrine of waiver means losing or giving up. Doctrine of waiver means losing or giving up. Next point is that waiver is voluntary relinquishment of legal rights. Waiver is voluntary relinquishment of legal rights. Next point is that citizens have no rights to waive the fundamental rights. Citizens have no rights to waive the fundamental rights. Next, we can come into the questions related to that topic. First question is that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Discuss with the help of law. What is that question? The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Discuss with the help of case law. Next, second question is that whether the laws made earlier to the commencement of the Constitution of India are exempted from the operation of Article 13 subsection 2. Whether the laws made earlier to the commencement of the Constitution of India are exempted from the operation of Article 13 subsection 13 bracket 2. 13 subsection 2. Okay, please answer that questions carefully. Okay, next we can come into the problem and solution. One problem and solution. Problem is that X had contested in general elections against Mrs. Y for Lok Sabha. X had contested in general elections against Mrs. Y for Lok Sabha. Mrs. Y was elected and her party won a sweeping majority. X alleged that Mrs. Y used the bribery. As usual, yes, government machinery and resources to gain an unfair advantage in contesting the election. X alleged that Mrs. Y used bribery, government machinery and resources to gain an unfair advantage in contesting the election. The High Court invalidated Mrs. Y's election on the ground of corrupt practices. Meanwhile, the Parliament enacted the 39th Amendment, withdrawing the jurisdiction of all courts over election disputes involving the Prime Minister. X challenged the said amendment in Supreme Court on the ground that it violated free and fair elections. X challenged the said amendment in Supreme Court on the ground that it violated free and fair elections. Decide. The issue of this problem is that whether clause 4 of the 39th Amendment Act 1975 is valid? No. Whether clause 4 of the 39th Amendment Act 1975 is valid? No, that is void. Whether withdrawal of the jurisdiction of courts over election disputes valid? Whether withdrawal of jurisdiction of courts over election disputes valid? No, that also void. Whether the concentration of X is valid? No, concentration, no, contention. Contention of X is valid? Yes. Whether the contention, that is that portion, whether the contention of X is valid? Yes. Whether the 39th Amendment affects the rule of law? Whether the 39th Amendment affects the rule of law? Yes. The rule is that section 123(7) subsection 7 of the Representation of the People Act 1951 Which rule? Section 123 subsection 7 of the Representation of People Act 1951. The Constitution 39th Amendment Act 1975. Another rule is that the Constitution 39th Amendment Act 1975. Articles are Articles 136, Clause 4 of the Articles 329A and 368. Article 136, Clause 4 of Article 329A and 368. The next law is that the Election Laws Amendment Act 1975. There are so many rules. That is, Section 123(7) of the Representation of the People Act 1951. The Constitution 39th Amendment Act 1975 according to the Article 136 Clause 4 of the Article 329A and 368. This next rule is that the Election Laws Amendment Act 1975. Yes, we can see that what is the application of this case. Raj Narayan had contested the Indian general election 1971 against Indira Gandhi, who won a sweeping majority in the Indian Parliament. Narayan filed a petition to appeal the verdict, alleging that Indira Gandhi used bribery, government machinery and resources to gain an unfair advantage in contesting the election. Narayan specifically charged Mrs. Gandhi of using government employees as election agents and of organizing campaign activities in the constituency while still on the payroll of the government. The High Court invalidated Indira Gandhi's election on the ground of corrupt practices. In the meanwhile, Parliament enacted the 39th Amendment to overcome the effect of the High Court judgment by withdrawing the jurisdiction of all courts over election disputes involving the Prime Minister. The amendment was made to validate with a retrospective effect the election of the Prime Minister, which was set aside by the Allahabad High Court. The question involved was the validity of Clause 4 of the Constitution 39th Amendment Act 1975. The contention was the clause in question wiped out not merely the High Court judgment but even the election of the law relating thereto. The Supreme Court struck down the clause on the ground that it violated free and fair elections, which were an essential feature forming part of the basic structure of the Constitution of India. The exclusion of judicial review in election disputes in the manner damaged the basic structure. Clause 4 was held constitutional on the ground that it was outright negation of the right to equity or right to equality conferred by Article 14, a right which is a basic postulate of the Constitution. It has been held that these provisions were arbitrary and were calculated to damage the rule of law. Next case we can discuss that Keshavananda Bharati versus State of Kerala. On the record 1973, Supreme Court 1461. It has been observed that apart from other reasons which were given in some of the judgments of the learned judges who constituted the majority dealt with the connotation of the word amendment. It has been held that the words amendment of the Constitution of India in Article 368 could not have the effect of destroying or abrogating the basic structure of the Constitution of India. Next case we can discuss that Taylor versus Beckham. 178 US 548 1900. American Supreme Court held that The determination of an election contest for the office of the governor is a political question and is not justifiable. It is a political question and is not justifiable. Thus, we can come into the conclusion that in the instant problem, Clause 4 of the 39th Amendment Act 1975 is not valid. Clause 4 of the 39th Amendment Act 1975 is not valid. The withdrawal of the jurisdiction of courts over election disputes is not valid. The withdrawal of the jurisdiction of courts over election disputes is not valid. The contention of X is valid because Clause 4 of the Constitution 39th Amendment Act 1975 is unconstitutional and void. Clause 4 is unconstitutional and void. Exclusion of judicial review in election disputes damages the basic structure of the Constitution of India and the rule of law. Exclusion of judicial review in election disputes damages the basic structure of the Constitution of India and rule of law. Okay. If any doubts, you can ask me. Thank you all. Thank you very much. Bye. Thank you all. Thank you for watching. Please subscribe and follow.